This is The Hidden History of Houston. I am your host, Vanessa Gilmore. For more than 26 years, I have served as a United States judge. During that time, I have been honored to present many Black history programs documenting and highlighting important cases decided in the courts of Houston and the surrounding area that have had an important impact on the lives of Black Americans. For the first time, I now have the opportunity to share this important history with you. The Hidden History of Houston will explore cases that began in the courts of Houston that contributed to the rich history of this city. Some of them involve the lives of only a few people locally, while others had a nationwide impact on the lives of many. This series will explore fascinating cases that tell the stories of Houston and its citizens that have been long forgotten, but shouldn't be. The Hidden History of Houston presents the United States of America versus Cassius Marcellus Clay, Jr., also known as Muhammad Ali. The case originally began with a suit by Muhammad Ali in the United States District Court for the Western District of Kentucky to prevent his induction into the armed forces. Clay had registered for the draft on April 18, 1960. On May 6, 1966, the Kentucky Appeal Board reviewed his request for conscientious objector status. The hearing officer reported his belief that the registrant was sincere in his conscientious objector claim. On November 25, 1966, the Kentucky Appeal Board recommended that the request for conscientious objector status be denied. Clay filed an administrative appeal of his initial denial to the Kentucky Appeal Board, which tentatively classified him as eligible for unrestricted military service and referred his file to the Department of Justice for an advisory recommendation. The DOJ concluded, contrary to a hearing officer's recommendation, that Clay's claim be denied, writing that Clay did not meet any of the three basic tests for conscientious objector status. 1. Openly opposed to war in any form. 2. That the opposition is based upon religious training and belief. And 3. That the objection is sincere. The appeal board denied Clay's claim on March 14, 1967. On April 28, 1967, the registrant, Muhammad Ali, appeared in Houston, Texas, and reported for, but declined to, submit to induction on the grounds of his religious beliefs as a minister of the Islam religion. Immediately thereafter, he was indicted. On May 8, 1967, the United States of America filed suit against Cassius Marcellus Clay, Jr. in federal district court in Houston, Texas, alleging a violation of the Selective Service Act for failing to submit to induction into the United States Army on grounds of his religious beliefs as a minister of the Islam religion. At the time, the defendant was the heavyweight professional boxing champion of the world, also known as Muhammad Ali. The defendant immediately filed a motion to dismiss the indictment against him. However, that motion was denied. The case was filed by the United States Attorney for the Southern District of Texas, Morton Sussman. In addition, a young African-American Assistant United States Attorney by the name of Carl Walker also represented the United States. The defendant was released on a $5,000 bond during the pendency of the case. Of interest, the bond lists the name of the defendant as Cassius Marcellus Clay, Jr., aka Muhammad Ali, but the bond is actually signed Muhammad Ali, also known as Cassius Clay. Muhammad Ali appeared for trial in Houston, Texas at the federal courthouse located at 515 Rusk Street. His defense team included lawyers from Atlanta and Chicago and a local attorney by the name of Matthew Plummer. The defendant, Cassius Marcellus Clay, Jr., was convicted by a jury in federal court in Houston on June 20, 1967, for unlawfully failing to submit to induction into the Armed Forces of the United States. Muhammad Ali appeared for sentencing after the jury's verdict. Judge Ingraham sentenced Muhammad Ali to a term of imprisonment of 5 years and a fine of $10,000. After his conviction, Ali filed a motion with the court seeking to leave the country so that he could appear for a fight. Muhammad Ali appeared for an oral hearing on his motion to travel. His request for permission to travel was denied. The defendant was ordered to surrender his passport. However, he was permitted to remain on bond pending the appeal of his case. The defendant filed an appeal of his conviction to the Fifth Circuit Court of Appeals, which is seated in New Orleans. His conviction was affirmed by the Fifth Circuit in 1968. The case was then appealed to the Supreme Court of the United States. The Supreme Court heard the case but decided to send it back to the trial court on April 22, 1969. The Supreme Court sent the case back to the trial court because it was revealed that Muhammad Ali had been subjected to wiretapping of 5 telephonic conversations by agents of the Federal Bureau of Investigation. When the case was returned to the trial court, the district judge found that the wiretap logs did not indicate that the information obtained had tainted the government's evidence. Ali sought discovery on this issue, but the court held that Ali was not entitled to further discovery and that the judiciary should not question the decision of the executive branch that wiretaps for the purpose of gathering foreign intelligence information are reasonable and necessary to protect national interest. The case was again appealed to the Fifth Circuit, who affirmed the decision of the district judge. The Supreme Court decided to hear the case again. On June 28, 1971, more than 4 years after the original conviction, the Supreme Court reversed the Fifth Circuit in a unanimous decision. They held that the Department of Justice had erroneously advised the board that they should disregard the hearing officer's finding of sincerity because of the circumstances and timing of the registrant's claim, and concluded that the induction notice was grounded upon an erroneous denial of Ali's conscientious objector claim and was therefore invalid. As a result of that ruling, Ali's conviction was overturned. Because he had previously been involved in the case, Mr. Justice Thurgood Marshall took no part in the consideration or decision of the Supreme Court. According to Bob Woodward and Scott Armstrong's book on the Supreme Court entitled The Brethren, the remaining 8 justices initially voted 5-3 to uphold Ali's conviction. However, Justice Harlan, who was responsible for writing the majority opinion, became convinced that Ali's claim to be a conscientious objector was sincere after reading background material on Black Muslim doctrine provided by one of his law clerks. Harlan changed his vote, tying the vote at 4-4. A compromise proposed by Justice Stewart in which Ali's conviction would be reversed, citing a technical error by the Justice Department, gradually won unanimous approval from the 8 justices. There is another interesting connection between Muhammad Ali and Houston. Ali was in Houston for much of 1976, as the bulk of the movie, The Greatest, was shot in Houston. During filming, Ali decided he wanted to make Houston his permanent home. Realtor Peggy Vallone sent Ali a letter that began, "The greatest for the greatest. Make Houston your home. Let us show you Houston's most palatial house." Ali and his entourage immediately toured a sprawling River Oaks mansion that was owned by Dr. Chester Reed. He soon agreed to purchase the house, minus some of the land, including the furniture and the linens, for $3.5 million. The deal fell through, however, with the leading urban myth being that prospective neighbors weren't in favor of having Ali in the neighborhood. The first African American did not move into River Oaks until 20 years later, in 1996, when I purchased my home in River Oaks. Realtor Peggy Vallone, who tried to close the deal between Muhammad Ali and Chester Reed, passed away on August 12, 2020, from COVID-related causes. She was just shy of her 96th birthday. Her obituary stated that initiating this deal with Muhammad Ali was the capstone of her career.